Your Honours, this is case number IT 9724A, the prosecutor versus Milomir Stakić.
Thank you. Mr. Stakić, can you clearly hear and understand the translation?
Good afternoon, Your Honours. Yes, I can understand you. May I be seated?
Something. Maybe I didn't get it. But yeah, something. I can't get it. Sorry, I didn't get your answer, actually.
Your Honours, good afternoon. Yes, I can understand you in my language. May I be seated?
Thank you.
I would now ask for the appearances of the parties. First, the defense.
Good afternoon, Your Honours. Branko Lukić and Mr. Jana Stojić for Mr. Stakić.
Thank you. Now for the prosecution.
Good afternoon, Your Honors. For the prosecution, Mark McKeon, Helen Brady, Xavier Nicole, Barbara Goy, and Katerina Margetts. Thank you.
Thank you. As the registrar announced, the case on our agenda is prosecutor versus Milomir Stakić. In accordance with the scheduling order issued on 16 March 2006, today, the appeal chamber will deliver its judgment. As stated in that order, this hearing for the delivery of the judgment is taking place pursuant to Rule 15 bis A of the Tribunal's Rules of Procedure and Evidence, in the absence of one of the judges of the appeal chamber, Judge Andresia Vas, who is unavailable for reasons of authorized tribunal business. Following the practice of the International Tribunal, I will not read out the text of the judgment except for the disposition. Instead, I will summarize the issues on this appeal and the findings of the appeals chamber. I emphasize that this summary is not part of the written judgment, which is the only authoritative account of the appeals chamber rulings and reasons. Copies of the written judgment will be made available to the parties at the conclusion of this hearing. This case concerns the appellant's role in the events that occurred in the new Municipality of Prijedor, Bosnia and Herzegovina, from 30 April 92 until 30 September 92. These events, which are set out in detail in the trial judgment, followed the 30 April 92 Serbian takeover of Prijedor and include atrocities related to the Omarska, Keraterm and Trnopolje camps. The trial began on 16 April 2002 and the judgment was rendered on 13 July 2003. The trial chamber found the appellant not guilty of the crime of genocide, count 1, complicity in genocide, count 2, and other inhuman acts, forcible transfer as a crime against humanity, count 8. The trial chamber found the appellant guilty of extermination as a crime against humanity, count 4, murder as a violation of the laws and customs of war, count 5, and persecutions as a crimes against humanity, count 6, incorporating the crimes of murder as a crimes against humanity, count 3, and deportation as a crime against humanity, count 7. The trial chamber imposed on Milomir Stakić the sentence of life imprisonment, qualified, however, by mandatory review after 20 years. Both the appellant and the prosecution appealed against this judgment on 1st September 2003, The hearing on appeal took place on 4, 5, and 6 October 2005. I will now briefly address the grounds of appeal in turn, starting with 3 of the prosecution's grounds of appeal, followed by 5 of the 7 of the appellant's grounds of appeal. The prosecution's appeal on cumulative convictions will be considered together with the appellant's appeal on cumulative convictions. Lastly, I will consider the appellant's ground of appeal on sentencing. Now turning to the prosecution's respective grounds of appeal. Adopting the order following the judgment, I will start with the prosecution's third ground of appeal. The prosecution argues that the trial chamber erred in law when, in the process of determining whether the appellant committed genocide, it declined to define the target group as all the non-Serbs in Prijedor municipality, and instead required the prosecution to establish genocide with respect to both Bosnian Croats and Bosnian Muslims. The prosecution further argues, in the alternative, that the trial chamber erred, in fact, when it found that there was insufficient evidence to show that the Bosnian Croat group was separately targeted by acts potentially amounting to the actus reus for genocide. The appeals chamber, Judge Shahabuddin dissenting, finds that the trial chamber did not err in concluding that the elements of genocide must be separately considered in relation to Bosnian Muslims and Bosnian Croats. Support for the view that a group targeted for genocide must be positively defined is found in the etymology of the term genocide, the drafting history of the Genocide Convention, subsequent discussion by experts, and Article 4 of the statute. The arguments suggested by the prosecution to the effect that a group can be subjectively defined are immaterial in reaching this conclusion. The subground of appeal is thus dismissed. The appeals chamber also rejects the prosecution's alternative argument that the trial chamber erred in fact when it found that there was insufficient evidence to show that the Bosnian Croats were a targeted group. It is true that the trial chamber identified a number of individual violence acts, the victims of which were members of the Bosnian Croat group. However, the fact that some Bosnian Croats, some Bosnian Croat properties, and some sites of importance to Bosnian Croats were victimized does not necessarily compel the conclusion that the Bosnian Croat group as such was targeted by acts that could constitute the actus reus for genocide. In light of the totality of the evidence concerning crimes against Bosnian Croats, it was not unreasonable for the trial chamber to have found that it could not conclude that the Bosnian Croat group was separately targeted. This ground of appeal is therefore dismissed. Next, turning to the prosecution's first and second grounds of its appeal. The prosecution raises 6 challenges to the trial chamber's conclusion that the appellant lacked the requisite dolus specialis for genocide. The appeal chamber will address each of these challenges in turn. First, the prosecutor contends that the trial chamber erred in considering the mens rea of others, namely the direct perpetrators of the crimes in Prijedor, rather than focusing on the appellant's mental state alone. The appeal chamber finds that it is clear that the trial chamber did not suggest that genocidal intent on the part of others was a prerequisite to convicting the appellant for genocide. Rather, it simply considered whether the apparent intentions of others could provide the indirect evidence of the appellant's own intentions when he agreed with those others to undertake criminal plans. The trial chamber also considered the direct evidence of the appellant's mental state, including his statements, and found it insufficient to establish genocidal intent. The appeal chamber sees no error in this approach. Second, the prosecution argues that the trial chamber improperly required it to prove an intent to kill all Bosnian Muslims in the region. The appeal chamber is not persuaded by this argument. In the very paragraph cited by the prosecution to support its argument, the trial chamber specifically found that the prosecution had not proven that the appellant sought to destroy in part the Muslim group. The trial chamber's reference to structures being in place to kill all Muslims merely constitutes evidence that the appellant did not seek to destroy the Bosnian Muslim group in whole or in part. The appeal chamber considers that the trial chamber did not err under the circumstances in this case in concluding that the appellant lacked dolus specialis for genocide. Third, the prosecution argues that the trial chamber confused motive with intent, erroneously concluding that because the appellant's ultimate motive was simply to remove the Bosnian Muslims from Prijedor, he did not intend to destroy the group as a means to that end. The appeal chamber finds, however, that the trial chamber expressly distinguished between the goal of the operation, that is, motive, and the methods that the appellant intended to employ in order to bring that goal about. With respect to the latter, the trial chamber found insufficient evidence of an intention to achieve the goal by destroying in part the Muslim group. The trial chamber specifically considered whether the appellant intended to achieve his goal through particular actions, including killing and the imposition of inhuman conditions of life, which could, if proven, amount to genocide. The appeal chamber finds no error in this approach. Fourth, the prosecution argues that the trial chamber erroneously failed to consider the appellant's intent to inflict conditions of life calculated to bring about destruction, focusing exclusively on acts of deportation. The appeal chamber finds that while the trial chamber did not specifically discuss whether the conditions that prevailed in detention camps and deportation convoys constituted evidence of this intent, a trial chamber need not spell out every step of its analysis. Rather than repeating itself unnecessarily, the trial chamber referred back to its analysis in previous paragraphs in relation to the appellant's mental state. For instance, its conclusion that the appellant's public statements suggested that his intention was only to displace the Bosnian Muslim population and not to destroy it. This analysis was equally applicable to all of the alleged genocidal acts, including the imposition of intolerable living conditions pointed to by the prosecution. The trial chamber's own factual findings elsewhere in the judgment illustrate that it was well aware of the evidence demonstrating the terrible conditions in the camps and on deportation buses, but it nonetheless concluded that it was insufficient to prove the mens rea for genocide. The appeal chamber sees no error in this approach. Fifth, the prosecution contends that the trial chamber failed to draw proper inferences from the appellant's utterances. While the appeal chamber agrees that utterances might constitute evidence of genocidal intent, even if they fall short of express calls for a group's physical destruction, it finds on the facts of this case that the trial chamber adequately and reasonably consider the appellant's derogatory statements and propaganda in paragraph 554 of the trial judgment. The prosecution has therefore not demonstrated that no reasonable trial chamber could fail to conclude that the appellant's utterances demonstrated his genocidal intent beyond reasonable doubt. Finally, the prosecution contends that the trial chamber improperly compartmentalized its inquiry, considering the mens rea evidence separately with respect to the various genocidal acts alleged, rather than taking into account the totality of the evidence, and that it ignored or gave insufficient weight to several categories of relevant evidence bearing on the appellant's mens rea. The appeal chamber agrees with the prosecution that the trial chamber's compartmentalized mode of analysis obscured the proper inquiry. Rather than considering separately whether the appellant intended to destroy the group through each of the genocidal acts specified by Article 4.1a, b, and c, the trial chamber should expressly have considered whether all of the evidence taken together demonstrated a genocidal mental state. Nonetheless, it does not appear that the trial chamber's piecemeal approach had any effect on its conclusion. The reasons it gave with respect to Article 4.1b and c simply cross-referenced its analysis of mental state with respect to Article 4.1a, in which it concluded that there simply was no evidence in the record that proved that the appellant sought to destroy the Muslim population. In reaching this conclusion, it must be assumed the trial chamber was aware of its own factual findings, but found them insufficient to establish intent beyond a reasonable doubt. Further, when the prosecution appeals from factual findings against it, it bears a heavy burden of persuasion. The appeal chamber cannot conclude that the evidence in this case is so unambiguous that a reasonable trial chamber was obliged to infer that intent was established beyond a reasonable doubt. To the contrary, the evidence could reasonably be seen as consistent with the conclusion the trial chamber did draw, that the appellant merely intended to displace but not to destroy the Bosnian Muslim group. In short, the first three prosecution grounds of appeal are dismissed. Next, we turn to the mode of liability in this case. In its analysis of the appellant's responsibility, the trial chamber specifically rejected the application of joint criminal enterprise as a mode of liability, despite the fact that it had been pleaded by the prosecution both in the indictment and at trial. In lieu of joint criminal enterprise, the trial chamber applied a mode of liability which is termed co-perpetratorship, which is new to the jurisprudence of this tribunal. Although neither party has appealed the trial chamber's application of this mode of liability, the general importance of this issue to the application of the law warrants the scrutiny of the appeal chamber proprio motu. The introduction of new modes of liability into the jurisprudence of the tribunal may generate uncertainty, if not confusion, in the determination of the law by parties to cases before the tribunal, as well in the application of the law by trial chambers. To avoid such uncertainty and ensure respect for the values of consistency and coherence in the application of the law, the appeals chamber must intervene to assess whether the mode of liability applied by the trial chamber is consistent with the jurisprudence of this tribunal. The appeal chamber finds that the mode of liability of co-perpetratorship as defined and applied by the trial chamber, does not have support in customary international law or in the settled jurisprudence of this tribunal. As the trial chamber erred in employing a mode of liability which is not valid law within the jurisprudence of this tribunal, its decision as to the mode of liability it employed in the trial judgment is invalidated. To remedy this error, the appeal chamber applies the correct legal framework, that of joint criminal enterprise, to the factual conclusions of the trial chamber to determine whether they support liability for the crimes charged. Although the indictment does not expressly refer to categories of joint criminal enterprise liability, the allegations therein nonetheless made it clear that the prosecution intended to rely on both the first and third categories of joint criminal enterprise. Upon a close review of the trial judgment, the appeal chamber holds that the trial chamber's factual findings support the conclusion that the appellant participated in a joint criminal enterprise, the common purpose of which amounted to the commission of the crimes against humanity of persecutions, deportation, and other inhuman acts, forcible transfer, punishable under Articles 5H, 5D, and 5I of the statute, against the Bosnian Muslim and Bosnian Croat populations of Prijedor. The appellant shared the intent to further this common purpose and had intent to commit the underlying crimes. Further, the appeal chamber holds that the factual findings of the trial chamber demonstrate that a natural and foreseeable consequence of the implementation of this common criminal purpose was the commission of the crimes of extermination and murder. The appellant, who participated in the implementation of the common purpose, reconciled himself with the likely commission of these crimes. In light of the foregoing, the appeal chamber concludes that the trial chamber's factual findings support the appellant's liability for the crimes against humanity of persecutions, deportation, and inhuman acts, forcible transfer, pursuant to the first category of joint criminal enterprise, and for the crimes against humanity of extermination and murder, and the war crime of murder, pursuant to the third category of joint criminal enterprise. In various sections of his appeal brief, the appellant has raised a number of arguments challenging the trial chamber's use of dolus eventualis as a form of mens rea, submitting that the trial chamber impermissibly enlarged the mens rea required for the crimes against humanity of murder, extermination, and persecutions, as well as the war crime of murder, and that by doing so, the trial chamber violated the principles of nullum crimen sine lege and in dubio pro reo. Since the appeals chamber has established the appellant's responsibility via the mode of liability of joint criminal enterprise, the appeal chamber has addressed these arguments in the context of this mode of liability. The appeal chamber notes that the mode of liability of joint criminal enterprise was recognized as a mode of liability in customary law as early as 1992, and that it has been clarified in the jurisprudence of the appeal chamber that the use of dolus eventualis within the context of the third category of joint criminal enterprise does not violate the principles of nullum crimen sine lege and in dubio pro reo. On this basis, the appellant's challenges must fail. Next, we turn to the appellant's first ground of appeal, which contains three subgrounds concerning the alleged expansion of the indictment by the trial chamber. In his first two subgrounds, the appellant alleges that the trial chamber erred by relying on acts originating outside the time period of the indictment and by preventing him from contesting the alleged error during the proceedings at trial. The Appeal Chamber finds that some of the acts referred to by the appellant constitute material facts which must be pleaded, while others amount to evidence which need not be pleaded. The material facts referred to by the appellant, including his authority and role in the joint criminal enterprise during the indictment period, were properly pleaded. The remainder of the acts referred to by the appellant, in fact, constituted evidence and therefore did not need to be pleaded in the indictment. Further, the appellant has not shown, by reference to either the trial record or the trial judgment, that the trial chamber prevented him from introducing relevant evidence. Therefore, the appellant's first two sub-grounds of appeal are dismissed. In his third sub-ground of appeal, the appellant submits that the indictment did not sufficiently inform him as to how his status as commander could be used as an aggravating circumstance in determining his sentence, and that he was therefore prevented from contesting this matter at trial. The Appeal Chamber finds that this submission is inconsistent with the jurisprudence of this tribunal. The Appeal Chamber has previously found that, as a matter of principle, there is no requirement that the prosecution plead aggravating factors in an indictment. This ground of appeal is accordingly dismissed. In the second and third ground of appeal, the appellant alleges a number of factual and legal errors which he argues denied him a fair trial, occasioning a miscarriage of justice.